Why contract drafting is the agent's greatest risk point. As we bring Chapter 1 together, everything we have discussed, valid contract elements, negotiation, and formation, now converges into one critical skill: contract drafting. This is where theory becomes reality. This is where deals either hold together or fall apart. In commercial real estate, poorly drafted contracts are one of the leading causes of disputes, lost commissions, and disciplinary action. Under AAC R4281101, licensees are required to exercise reasonable care, skill, and diligence. Contract drafting is one of the clearest places where that standard is tested. If terms are vague, missing, or inconsistent, the agent may be exposed to liability under ARS paragraph 322153 for negligence, misrepresentation, or failure to protect the client. Clarity over complexity. Writing contracts. That work commercial contracts are often lengthy and complex, but complexity does not equal protection. In fact, unclear language creates risk. The goal of contract drafting is clarity, ensuring that every term is specific, measurable, and enforceable. For example, instead of stating seller to make necessary repairs, a well-drafted contract would specify seller to repair HVAC unit serving Suite 200 to operational condition by licensed contractor prior to close of escrow. This level of detail removes ambiguity and reduces the likelihood of disputes. Courts in Arizona will generally enforce the plain language of a contract, meaning if something is unclear, it may be interpreted in a way that neither party intended. Using the commercial contract as a risk management tool, the 2026 Commercial Real Estate Purchase Contract is designed to allocate risk between the parties. Each section, property description, earnest money, due diligence, remedies, serves a purpose in protecting one or both sides of the transaction. For example, the due diligence section allows the buyer to investigate the property and cancel if issues arise. The remedies section outlines what happens if one party defaults. These are not just contract terms, they are risk management mechanisms. As an agent, your role is not to practice law, but to understand how these provisions function so you can guide your client effectively and ensure the contract reflects their intent. Common drafting mistakes that lead to liability. Many of the issues seen in commercial disputes stem from simple but critical drafting errors. One of the most common mistakes is failing to include all negotiated terms in writing. As discussed earlier, under ARS, paragraph 44101, if it is not in writing, it is not enforceable. Another common issue is conflicting terms between the main contract and addenda. For example, a purchase contract may state a 30-day due diligence period, while an addendum states 45 days. Without clear language indicating which term controls, this creates confusion and potential legal disputes. Agents also frequently fail to clearly define timelines. In commercial real estate, timing is everything. Missing a deadline due to vague drafting can result in loss of earnest money or cancellation of the contract. Disclosure and drafting, where risk meets responsibility. Drafting and disclosure are closely connected. As highlighted in the commercial SPDS, sellers are required to disclose all known material facts about the property. Failure to do so can result in liability and claims of fraud. The case of Hill v. Jones reinforces this principle, establishing that sellers must disclose material defects that are not readily observable. In a commercial setting, this may include environmental issues, zoning violations, or existing lease disputes. As an agent, you must ensure that disclosures are not only provided, but properly integrated into the contract. This may include referencing disclosures in the agreement or incorporating them as exhibits. Real-world breakdown, when drafting fails. Let's look at a real-world scenario. A buyer is purchasing a commercial property in Glendale and negotiates a credit for roof repairs. The agent writes in the contract, seller to credit buyer for roof. No dollar amount, no timeline, no scope of work. At closing, the seller offers a minimal credit, arguing that the contract did not specify an amount. The buyer expected a full replacement cost. A dispute arises, delaying closing and potentially leading to litigation. This entire situation could have been avoided with proper drafting. Seller to provide a $75,000 credit to buyer at closing for roof replacement. This example highlights a key takeaway. Vague language creates risk, while precise language creates protection. Broker supervision and accountability. Under AAC R4281103B, designated brokers are required to supervise all transaction activity, including contract drafting. This means that errors in contracts are not just the responsibility of the agent, they reflect on the brokerage. Many brokerages, including yours, implement internal policies such as required document submission timelines and contract review procedures. These are not just administrative rules, they are risk management systems designed to protect both the agent and the broker. Failure to follow these systems can result in internal discipline as well as potential adverse action. Bringing it all together, the foundation for Chapter 2. Chapter 1 has built the foundation for everything that follows. We started with understanding the modern legal landscape, moved into the elements of a valid contract, then into formation and negotiation, and now into drafting and risk management. As we move into Chapter 2, we will take everything you have learned and apply it directly to the commercial purchase contract itself. You will begin to see how each section of the contract reflects the legal principles we have discussed and how proper drafting turns those principles into enforceable agreements. This is where you transition from understanding the law to mastering its application. Online discussion. Why is vague language one of the biggest risks in commercial contract drafting? Answer: vague language creates ambiguity, which can lead to disputes over interpretation. Courts will enforce the written terms, and if those terms are unclear, the outcome may not reflect the intent of the parties, increasing legal and financial risk. How does the statute of frauds impact contract drafting in commercial real estate? Answer: it requires that all material terms of the agreement be in writing to be enforceable. If negotiated terms are not included in the contract, they cannot be legally enforced, even if both parties verbally agreed. What role does broker supervision play in contract risk management? Answer: brokers are responsible for reviewing and supervising transactions to ensure compliance with laws and regulations. This helps catch errors, ensure proper documentation, and reduce the risk of legal or disciplinary issues.